Are we on? No, we're not on mute.
Oh. Good afternoon, everyone. This is Janet in the peer office. Can I ask everyone to make sure they mute their lines unless they're speaking, otherwise we'll have a lot of feedback. I'm going to do a roll call of the sites, and then I'm going to turn it over to Joanna Fisher with disability determination. So to get us started, Aberdeen, are you guys on?
Yes.
Aberdeen District Service Center?
Yes.
Okay. Brookings DHS?
Brookings is here.
Thank you. Chamberlain?
Hello, Janet. Can you hear us?
Yep, I can hear you. Thanks.
Yep, you're welcome.
Eglay, are you on? We'll come back. Mitchell, are you on?
Baby nephew.
Mitchell's here. Thanks. Here, DSS in the Knight building. Are you guys on?
Yep, we're here.
Okay. Rapid City DHS.
We're here.
Okay. Rapid
We're
City
here.
DOT.
We're here.
All right. Sioux Falls DDS. You're on. You're on? Okay. Sioux Falls DHS.
We're here, Janet.
Sioux Falls Rehab Center. Sioux Falls Rehab Center. Carmen, are you on?
Come on.
Okay. Watertown.
We're here.
Yankton.
Yankton's here.
Want to come back to the Rehab Center in Sioux Falls? Are you guys on? Eglay, are you on?
Yes, I am here.
All right. Okay, I'll check on the Rehab Center. I see that, Joanna, has already got the PowerPoint up on the screen for everyone to see. You should also all have a sign-in sheet. So get that filled out and send back to me after this training is over with. This is being recorded also, so if you're not able to watch it or you have someone that you know wants to watch it, make sure to let them know that it is being recorded, and we'll get it out on our DHS intranet site, and we'll share that information as we go along. I'm going to turn it over to Joanna Fisher. Joanna, you want to take over?
Okay. Well, welcome everybody. We are excited at the Disability Determination Services to present to you today. We're going to take a brief moment here to just do a quick introduction to the individuals that will be helping out with the presentation. If you can't hear us, let us know. We're going to hopefully be able to use and have the mic stationary for the presentation. So just let us know if you can't hear us. Well, I'm Joanna Fisher. I'm the administrator here at the DDS. I've been the administrator for about 4 years and been with the DDS for about 15 years. So I will turn it over to Jeremy here.
Sure, I'm Jeremy Sanford. I'm one of the supervisors here in the office, and I'm also the professional relations officer for our agency. And I've been with the DDS for about 8 years and in my position for about 3.5.
I'm Angela Rowe, and I've been with the DDS for 13 years. I'm also a supervisor, and I get the fun of doing training and quality assurance, and love my work here.
I'm Katie Wink. I am the operations supervisor at the Social Security office in Sioux Falls. I've been there for just about 9 years, and in that time frame I've been the customer service rep that answers phones. I've taken claims. I've been our technical expert and now the operations supervisor.
All right, so we can answer Social Security questions that are beyond our scope. So we thank Katie for making the drive over and helping us out. We're going to go ahead and just allow questions that you might have throughout the presentation. If we feel that there is any questions we'll handle later, we'll defer those, but feel free to chime in. But other than that, I think I'll turn it over to Jeremy to get us going.
All right. So you have the PowerPoint available to you, and it's going to be displayed on your screen as well. So as you can see, we have 3 topics really we want to go through today. We're going to give an overview of the DDS and Social Security disability determination process and what that looks like. And then we're going to talk a little bit about record sharing and requesting and providing records from the DDS, and then also back and forth with vocational rehab and any other agencies that might be on as well. So, and then we'll have a time for question and answer at the end. If your question doesn't get answered while we are in the midst of the presentation. So, the Social Security Administration has 2 different disability programs, and we're going to talk about those. There's the Social Security benefits for workers, and then there are also benefits for children and adults who are individuals who are maybe low income, have very little resources available to them. So you could be applying for 2 different types of pots of money essentially when you're thinking about applying for disability. And so we're going to talk about the Social Security Disability Insurance Program here a little bit. There are work eligibility requirements go into that, and the disabled person has to have had recent work, and they've paid into the Social Security system. So you pay in those FICA taxes off of your paycheck. That's going to be what that pot of money is coming out of. So you have to have worked enough work credits in order to qualify for this, and depends on your age and the time the disability starts in terms of what your benefit might be. For SSDI, the benefits include, there's a cash benefit that's based on your work history. So again, it can vary depending on how much you've paid into the system in the past. You're also automatically enrolled into Medicare. There is a 24-month waiting period, so that's something to be aware of. And there is a 5-month waiting period for the cash benefit to also kick in with this particular program. So, the next one we'll talk about is SSI. So that stands for Supplemental Security Income. There are some eligibility requirements for that as well. So this is available to both adults and children. There is an income limit and resource limit that the individual has to meet, and so Katie and her staff work on figuring that out with the individual. There's a $2,000 individual limit, a $3,000 couple limit in terms of assets and resources. So SSA does not take into consideration things like one's home and first car. So there are some things that people can have in terms of assets that are not counted against them. So for children, the parental assets and income are considered. So just because of a child is maybe born with a disability, they aren't necessarily automatically going to qualify for this program. Their parents have to meet the asset and income limits as well. The benefits for SSI, there's a federal benefit rate, so it's standard across the board for everybody. And in 2017, that rate was at $735 for an individual, and then for a couple, if they are considered to be married, is $1,103. And you qualify for Medicaid at the time that the claimant is found disabled, so there's no waiting period for that, and there's no waiting period for the cash benefit either. So that is one benefit that is available that is not the same as SSDI. In terms of applying for Social Security disability, probably the best way to do it is to apply online. I don't know, Katie can probably speak a little bit about that. Are you able to apply for both SSI and SSDI online?
The disability you can apply for fully online. The SSI right now, they're kind of revamping that whole application, and online right now you can apply if you are a U.S. citizen, never married, over 18, and if you have not filed before. And it does basically what's called a deferred application, so it doesn't ask you the full realm of questions. So there will be a point, if somebody applies for that SSI online, that Social Security will contact them before it goes to DDS, or for sure after it comes back from DDS.
Okay, good. You can also apply by telephone as an option. There's a national telephone number you can call that has people who staff the lines, and they'll go walk through the entire process with the claimant, get the information that they need, and get that forwarded on to where it needs to go. And I believe you can apply in person too. Usually that's done by appointment. Is that correct?
Yep, you have to call in for an appointment to do it either in the office or over the phone. I don't know about all of the offices in the state, I guess, but right now Sioux Falls, probably Watertown and Yankton too, are at about a 3 to 4 week waiting time to get an appointment. So that's why it is quicker to do it online, because we basically see those applications the next day and can start processing them right away, as opposed to waiting that 3 to 4 weeks for an appointment.
Good. Yeah. All right.
So any questions at this point on the Social Security side of things? All right, we'll keep on going.
So in front of you now, this is an example of the website that Social Security has for applying for benefits, and you can see on the right-hand side there are links, and even within the text there, you can apply for disability benefits by clicking on that. So they make it very easy to apply online. I think it's very user-friendly as well. So this is another just example of what that looks like. All right. So what happens next? Once an application is received by the Social Security office, they are going to forward that information on to the Disability Determination Services, and that's where we step in. And our job really is to make the medical determination of eligibility regarding the claimant's impairments that they are alleging. Before we jump into that, I just wanted to just provide some tips for applicants and anybody that you might be working with who's applying for disability. There are some things that I really like to convey to individuals in order for their claim to be processed in an expedient way and to make sure that we have all the information that we have. So I would say when an individual is going to be applying, be prepared and thorough when initiating that application. A complete list of medical providers is very helpful to have dates of treatment, addresses, those kinds of things. And like it says there, failure to be thorough will result in delays. Oftentimes we will discover that an individual has seen maybe a doctor or provider that they did not list, and when that happens, we have to then go out and request those records, and then we have to wait for them to arrive. So, and that is just a situation that's delaying the processing of the claim. So, additionally, I would say I really encourage people to keep in touch with us. So if they are changing their telephone number, if they're moving, if they have any medical updates, to be letting us know that and working with their analyst or their examiner to keep those lines of communication open. So, any questions on that? All right, well, I'm going to turn it over now to Joanna, and she's going to give us some information.
All right, so we're starting to talk about one of my favorite subjects, which is the DDS. And the main purpose for the DDS is we're responsible for making the disability decision for Social Security disability claims. So Jeremy will get a little bit more into the detail as far as the responsibilities here in a minute. But that's the main point. And because we are working with Social Security, we're 100% federally funded. And so we, a lot of times in my position, that's one of my main things that I juggle is the communication back between the Social Security Administration and between the state parent agency, which is a lot of you out there in on the presentation. So as far as we not only need state approval for things such as travel, hiring, we also have to get Social Security approval for those as well, because if the funding isn't there, we can't proceed to do it. So while my main boss is the state, but I always have to go through another loophole with the Social Security Administration. There's also 54 DDSs across the nation. Several of the states are decentralized. That means they have several DDS offices around their state. South Dakota, with our population, we're centralized. We're the only DDS in the state of South Dakota. Obviously we're located in Sioux Falls. We used to be located in Pierre when this was originally started, but I think they had a hard time keeping us staffed, so they allowed the move to Sioux Falls. There's a common set of policies and guidelines that make that we use to make the disability determination services. Those aren't written up locally. Those are national policies. And I've heard claimants before say it's easier to get a decision made in another state, I'll just say Idaho, for example, versus South Dakota. Well, really those kind of statements are just completely false. What they're using for a basis really isn't based on real true fact. We also have 25% of our claims that we complete get selected for external quality assurance review, and that helps also with that national consistency to make sure that we're maintaining the policies and guidelines. As far as how our staff is structured, we've got 31 and a half employees at the DDS. That makes up, we've got 17 examiners. We've now actually started calling them analysts, disability claims analysts. We have 3 specialists as well, and those are team leads. That's kind of a promotional position for those analysts. We have 5 medical doctors consulting with us, 1 psychiatrist, 1 pediatrician, 1 child psychologist, and 7 psychologists. So we work with a number of doctors that help, and we keep them fully busy, and we actually could use more medical doctors. If you know any medical doctors around the state, let us know. We'll be more than happy to work with them to assist in consulting or doing exams for us. But we currently send a lot of cases out of state because of our lack of medical doctors. So hopefully, and that just slows down the processing time. Right now we're able to have the assistance, but there are times that the national assistance isn't there for us. So, and then we also do work with quite a few consultative exam providers. Those are doctors' offices that are willing to assist in doing exams for us, either physical exams or mental health exams at varying degrees. So, and we only do that for insufficient evidence on claims. All right. So is that back to you?
All right. Excuse me. So just to give you a visual about the different responsibilities that are divided between Social Security and the DDS, the Social Security Administration is responsible for all of the medical case development. They process the application. They work on the work issues. And they prepare that claim to be sent to our office so that we can do our work. At the DDS, then, we work on developing the medical evidence. So we're going to go out and request records from the medical sources that were listed on the application. We're going to make sure that we have enough information to make a decision, and if not, then we'll purchase more, and we'll talk more about that here in a minute. And then making the actual medical determination in the end. So we're going to now look at how SSA defines disability and break it down a little bit and talk about the various aspects of it. The law defines disability as an inability to engage in substantial gainful activity, which we often refer to as SGA. There has to be a reason that's medically determinable, whether it be physical or mental, and then that impairment has to be expected to result in death, or has to be expected to last for a continuous period of not less than 12 months, or may have already lasted that long. So you can see there's a number of elements that go into the definition, and it's fairly specific. The one thing to know is that the definition is the same for both types of claims, as we talked about earlier, SSDI and SSI. So when we are processing those claims, we don't necessarily have to use different rules or a different definition. The definition remains the same. So we're going to talk a little bit about the substantial gainful activity portion. That's important. It's really based on the earnings of the individual. And if an individual is earning SGA in 2017, that threshold is $1,170 per month. For blind individuals, it's a little bit more. It's $1,950 per month. But that is the threshold that we're going to be looking at, or the Social Security office actually will be looking at before they actually even send it to us, to make sure that this person is earning under that dollar amount. If they are earning above that dollar amount, well, then they're not going to be meeting that definition of disability right off the bat. So that's one thing to know, and there's a lot of information out there about how much money can I earn, and what does that look like once you're on benefits, how much money can I earn. So those are all things to be considered. Medically determinable physical or mental impairment. So that's another aspect of the definition that I wanted to talk a little bit about. So when we're making a determination about eligibility, or making sure that an individual is meeting the definition of disability, we really have to have some objective findings to go on. So we are looking at those medical records and trying to determine, are there laboratory findings, are there exam findings that we can look at and really show that this person has this impairment that they are alleging, And one thing to know is that in the past, symptoms had been considered when we were establishing that medically determinable impairment. So we would look at things like pain, things like that. So symptoms are not as much considered when we're establishing MDI as they used to be. And the other thing to know is that evidence has to be established from an acceptable medical source, and we'll talk about what that means here in a moment as well. So, lastly, the duration period is important to note. So the impairment must have lasted or expected to last 12 consecutive months, and also, a claimant may have worked within that 12-month period. However, when we're looking at the medical evidence, we're trying to establish how long that person has had this impairment going on, and to what severity that might look like. So it's important for us to be able to find some longevity within the record. It's important to note this is not a short-term disability program. It's something that is intended to be more long-term. So that's the reason for the 12-month consecutive period. So as I had mentioned before, the next thing we wanted to look at is once we're trying to establish if this person is meeting the eligibility criteria, whether or not they are meeting the definition of disability. And so we got to go out and obtain medical records from the claimant's treating providers, and that information is absolutely vital. And when we do that, we're looking at various sources of information. One of them is an acceptable medical source. And we're going to talk a little bit about, Angela's going to touch on what that means and what that looks like. We're also looking at information from other professional providers and then collateral sources, and we'll define those here in a moment as well. So with that, I am going to turn it over to Angela, and I'll have her talk a little bit about acceptable medical sources and maybe some changes that have come across here recently.
Well, as you see, there are listed the acceptable medical sources that we're looking for within the medical records to establish those medically determinable impairments. So licensed physicians, licensed psychologists, licensed optometrists, speech language pathologists, and licensed podiatrists. And so those folks are going to be critical to establishing that medically determinable impairment. Now, we can use other sources to support that information as long as we have one of those providers supporting the medically determinable impairment. And since Jeremy has already flipped the slide over to some changes that have occurred within the program, we had some significant regulation changes to how we look at medical evidence as of March 27, 2017. And this change, I believe, has or will have a good impact, I would think, on a state like us. That now we are able to look at accepting folks that have a medically determinable impairment established by a licensed physician assistant, a licensed audiologist, or a licensed advanced practice registered nurse. The SAE has kind of taken a stance that the medical treatment has changed over the years, we see more of a team approach, number one, in that doctors oftentimes have other individuals with them, and they approach their work with the patient in a broader, I should say, light, because if they're not available, they're going to see their PA, for instance, or they're going to see their CNP. And that's a lot more common, I think, than it used to be. And I think in a state like South Dakota, it's certainly more common in the rural communities to have PAs and CNPs, probably providing the majority of treatment to folks. So this is an important change because we're hoping that we're not going to have to get as many consultative exams because we're going to have more folks that are actually receiving treatment from now these acceptable medical sources. And another example would be when you have to see a specialist, surgical orthopedist, for instance. You might see that person initially, and the second person you're going to see for follow-up is probably going to be their PA. And so those are some of the changes for the acceptable medical sources. And it's also impactful because hopefully now we can recruit some of these folks to be consultative exam providers for us as well. And this is a change. March 27th is kind of a golden date now for us because we have to pay attention to application filing dates now to distinguish how we adjudicate and look at claims before and after that date. And that date is going to carry through for folks who are in the appeal process as well. So if there's any questions on that, I'm open to hearing that now. Otherwise, we'll continue.
All right. As Angela had mentioned, there are other important sources of evidence that we also are going to look at For instance, counselors, social workers, vocational rehab counselors. The documentation they provide is often very critical as well. It provides detailed information about the person's function, how they are managing life in a day-to-day manner. So, as I said, that information is also very important when we're adjudicating the claim. So, we definitely don't want to diminish those at all. There's just a difference between how we have to go about establishing the medically determinable impairment versus other information. The processing continues. The DDS claims examiner will review the records. So they'll go through all the information. They're going to document that information in a web-based program that we use to adjudicate the claim, and then we're going to establish that medically determinable impairment and determine the severity of the impairments or the combination of impairments depending on what the allegations of the claimant are. As I had mentioned before, incomplete medical information can become problematic when we're looking at the claim. If we don't have enough information, we really have to make a decision about how we're going to obtain that. Oftentimes we'll try to contact the claimant and see if they can provide us with any updated information. Maybe since the time of application they've seen a doctor or they've had some follow-up that we initially didn't know about, so that can be helpful. The other thing is we could contact a treating source. So if there's a doctor that they may have seen in the past that didn't provide information, let's say, we can contact them and try to find out if there is information. And they just didn't respond to our initial request. Lastly, we can purchase an examination, and Joanna had alluded to those providers across the state that we can tap into who provide consultative exams, and that is oftentimes a way that we'll get information as well. A little bit about what a consultative exam looks like. We're really trying to, again, gather information depending on the situation that will give us sufficient information or that will give us updated information. So if we don't have enough, that's one thing. The other thing is that we could have a whole slew of information. However, we need something that's more current. So that can be another reason why we might go out and get that. The evaluation is at no expense to the claimant, and so really the only effort that they have to make is trying to get themselves to that exam. And we are also willing to help with that in whatever way we can, and they can work with their analyst or examiner to help make that happen. And like I said, there are some reasons why you might need to get that exam. If we can tap into a person's treating source or their primary physician, we'll definitely do that. That's probably the best situation. Oftentimes, a treating source might not be willing to do that exam for various reasons, and so that might not be an option. But it's something we definitely look at.
All right. We've got a few myths intertwined with our presentation here today. So, does the DDS obtain a CE on every case? And that is actually a big no. We only order exams when there's insufficient evidence on a case. The main goal for the DDS analyst or examiner to do and analyze a case is we need to determine the most the claimant can do despite their impairment. And so if there's insufficient evidence based on that criteria, we'll order an exam. And I think our exam rate is, I don't think we have that elsewhere in the presentation. I think our exam rate is around 23% of cases we order exams on. So that's just a big falsehood that sometimes, or they just feel like they've had a referral their doctor has referred them to a specialist, so they just automatically assume the DDS can send them to their specialist. That is not our position. Our position and what we have to do is we are looking at functional information. We are not in the business of treatment. So the exams we send them to, our doctors are actually specifically told not to move forward with any kind of recommendations for treatment. If they do, that's really on their own, or it's their treating physician anyway, so they can do what they wish there. But that's not our role in the exams that we purchase.
Okay. Before we move forward, do you have any questions about those first steps, gathering information, how we go about getting the things that we need to make a determination? All right. So the next thing we're going to talk about is the 5-step process that we use in making a determination about eligibility for, let's say,
Excuse me, Jeremy?
Oh, sure.
Oh, hi, Jeremy. It's Vicki in Sioux Falls, and we had a question. Go ahead, Nancy.
Jeremy, it's Nancy. Do you only look for the past 3 years in medical records, or do you go back further, like 10? What do you want?
Yeah, it depends on the situation. I hate saying that because that seems like a catch-all, but it's true. With the medical records that we're requesting, we're going to be basing that on an application date, or it could be on a date that they filed, or it could be the last day that they worked. So there are a number of different factors that we look at when we're trying to establish how far back in the past we're going to look. So it depends on that. So Angela could maybe expound a little bit.
Yeah, I can give you something a little bit more definitive. Depending upon, there are some specialized type of claims that I'm not going to answer to, like disabled widow or CDB, childhood disability benefits for adults. Those are a little bit more specific. But if it's a Title 16 only, we go 12 months prior to the application date. And if it's a Title II, it usually ends up being the date last worked, and we'll go 12 months before that. We're really looking for current information. And so a lot of folks will give us medical records from many years ago, and that is really not relevant to us. We're looking for what their current function is, if that helps.
That is, thanks.
Yeah, thank you.
All right, thanks for the question. Okay, so we will move on to the process. The first step in the process, and this is something that is established by the Social Security Office, we're going to be looking, is the person performing substantial work? So we talked about the SGA, substantial gainful activity, earlier in the presentation. That's the threshold that we're going to be looking at to determine whether or not they're meeting this first step or not. And so if they're earning SGA, they would be essentially denied at that level, and that would be the end of the process. So the Social Security Office doesn't send us claims that don't get past number 1. So that's not something that we make a determination about here in our office. The next step in the process is number 2. Does the person have a severe impairment? So severe impairment, I know when I first started, seemed like kind of a subjective idea. But really, for Social Security's purposes, severe is meaning significantly limits the ability to perform basic work-related activities. So we're going to be looking at the person's medical records and seeing if there are things within that record that would suggest that the person would have some limitation in the ability to perform a work-related activity, such as standing or walking, lifting, maybe crawling, those kinds of things. So, for instance, if an individual has, a back problem, maybe had some back surgery, and they've had some limitations in their range of motion, those kinds of things, those are going to be indicators to us that, yes, there is a severe impairment that is going to limit their ability to probably lift weight. They wouldn't be able to lift an unlimited amount of weight, for instance. So that would be the threshold we're looking at. So most of the time, we do have a severe impairment that is existing when we take on a claim, and then we move on to the next step. Angela, do you have anything to add on severity?
Severity can definitely be a challenging element at times because there might be some conditions that are very well treated and then would cause the condition to be considered non-severe versus severe. One of the examples I often give to folks is hypertension. That's easily treated usually. So unless you're fainting, that's probably not going to cause a work limitation.
Yes, good point. All right. Any questions on severe impairment or the idea of severity? Okay. So we'll move on to number 3, the next step. Does the impairment meet or equal a listed impairment? So Social Security has a set of guidelines out there that list out by body system the requirements for meeting a certain listing of impairments that would automatically make them or find them to be disabled. And so that is something that is out there on the internet. You can actually go out and find it. And that's something I'll pull up here probably at the end and give you an example of to show you what the listing of impairments looks like. But they are, these are very severe, significantly severe situations that are really keeping the person from doing any gainful activity. So that's something to know.
And meeting a listing also takes into consideration that duration is going to be met.
Yes.
So the durational part of the definition is going to just about always typically be met by meeting a listing.
Yes. So as I had mentioned, the listings take into account things like medical history, findings on exams and test results, treatment and diagnosis and prognosis. So those are all things within the medical record we're going to be looking at and trying to match up. Do the things that we're seeing in the medical records match up with the listing of impairments that are out there? And so that's the first step that the examiner is going to take when they're looking at the claim.
All right, another myth that we hear quite often is, I should be automatically allowed because my doctor told me I should be. So, and most of the time, that statement, go ahead and, is false. And really it's the answer is not necessarily. A doctor's narrative describing an individual's function can really be helpful. If you have any role in assisting or guiding an individual applying for disability, a good narrative statement beyond, a poor doctor's statement that we can, as much as an MD might be in their signature, it's as worthless to us if they just say, John Doe is disabled, and they sign their name. That's as good as, file 13, I think that's where we would put that. I mean, we keep it a part of the file, but if there isn't any facts that base that statement up, it's as worthless to us, and I think that's a huge part of it. A narrative statement, function, any description of function that the doctor can observe, actually firsthand is actually better. A lot of times what we see is doctor statements where they're pretty much just writing down what the claimant is telling them to do, that their function is. What the best type of narrative is when they're personally observing it. See, Most doctors also don't know the specific requirements needed for Social Security disability, so they don't really know. I mean, they don't know if it's as easy as, a doctor's statement for getting a disabled parking sticker, or they deal with a range of disability criteria. There's a variety of disability definitions out there. The VA is another federal government agency, but they have a completely different criteria. They base their they base it on percentages. You can be 10% disabled at the VA, 20%. For us, it's really all or nothing, and it's based on the ability to work. So that's really the key points I wanted to say about that.
And when we see something like that, that's considered an opinion for us. And the program pretty much dictates that we have to look for consistency and supportability. That it needs to be consistent with all the other medical records, and it needs to be supported. So blanket statements such as "you're completely disabled" usually doesn't match up very well. And then we have to be able to state within the rationalization why we believe or not believe those statements.
Good. Any questions about that? Okay. So moving on to the next step. So most claims, frankly, don't meet a listing. And so we're going to move on to the next step, and that is looking at the impairment's prevention of any past work. So before we do that process here in our office, the examiner working alongside our medical consultants here in our office are going to evaluate the claimant's what we call residual functional capacity, or RFC, determine what the most the claimant can do, and make that evaluation process. So we use that evaluation then to really look at what is the claimant's ability to perform any past relevant work. So past relevant work is work that has been done within the past 15 years. So we're looking at a work history. We need to collect that information from the claimant, and that work has to have been done at an SGA level. So they had to have done it at whatever the threshold was for any particular year, and then they have to have done it long enough to have learned it. So there are some parameters there as well.
Yeah, and the 15 years isn't a typo.
No.
that is actually a very lengthy period of time, and some of the hardest work that we do at the DDS is really trying to collect that information, because that's also hard for the individuals that have worked it to even remember that far back. But we do need that. That is a requirement.
Yep. So at this step, we're going to really compare what the residual functional capacity of the claimant is with how they are going to describe the work that they've done in the past. So, and really try to match up what it is that they've told us with what it is that they're able to do. And if they're able to work within the capacity of any work that they've done in the past, we would say that they could return to that type of work. And then the other thing we would look at is if they can't do it as they've described it, can they do it as it's described in the national economy? And there is a dictionary of occupational titles that we use to look up different types of jobs and really to make a determination about whether or not they're able to do that work as it's done in the national economy. So at step 4, there's a lot of work that the analysts do, and as Joanna had said, it's a very involved process, and oftentimes that the claimant has to be involved in making that or getting that information. So again, it kind of goes back to what I was talking about before with the tips of being communicative with the DDS so that we can get in touch with the claimant whenever we need to. Any questions on step 4? Okay. So the last step in the process is step 5, and we're really looking at, does the impairment prevent any other type of work? And when we look at that, we're looking at really the evaluation of age, education, and any skills that they may have acquired from any past work that they've done. So there's a grid that Social Security has put together that we reference, and as I said, it's based on age and education, and we're looking at their RFC and trying to piece together where they fit within that grid system. So at this step, really, as I said, age is a big issue with step 5. So, any questions on that? All right. Have another minute.
All right. You must apply 3 times before being granted benefits. Now, this is probably the most common falsehood that we receive or that is talked about. We see it in the medical records. We see it in statements from doctors making these statements. And this is just completely false. In fiscal year 2016, the South Dakota DDS allowed nearly 2,000 initial claims and nearly 200 claims on the reconsideration, which is reconsideration level is the first level of appeal. So we've got over or about 2,200 claims that we allowed last year just in our office.
Okay, so before we move on, do we have any questions about the 5-step process? That's a very simplified version of the process, and if you ever want to know more information, I'd be happy to talk through that with you. Okay, so
Jeremy, we have a question in Sioux Falls.
Sure.
I just have a question about the age part. You said that you look at the age in making a decision. What are you looking at age? If they're young or old, or what are you?
Yep. Go ahead, Angela.
The more advanced age the person is, SSA finds that the more limitations you would have in result of your medically determinable impairments, it's going to be easier to be found disabled. It's felt that age is a factor, and so folks that are over the age of 50 and have maybe can't do medium or heavy work anymore, the likelihood of allowance, it does increase for folks either in if we're looking at more of like a light kind of work situation or sedentary, that age just plays a role, if that makes
Retraining.
Yeah, being able to retrain, or we'll see a lot of folks who have maybe done heavy labor, and then it's just more complicated and difficult for them to be able to make that transition to doing maybe work that they've never done before.
Okay, thank you.
This is Carmen in Huron.
Yes.
What about people who have just been diagnosed with something that is supposed to get progressively worse as they go on with the illness?
Yeah.
When they first apply, it might not be so bad. Should they wait to apply, or?
Well, I guess it depends on what it is. Some of the listings for impairments like MS is a good one. It can be relapse and remitting. So sometimes they're going to be worse off than they are other times, but it can be progressive in nature as well. So while they apply, we're going to be looking at the criteria of the listing itself. So that'll be the first thing that we'll look at. And as I had said, the criteria in the listings is pretty significant. So you have to have some pretty significant impairment going on to meet the listing. So if you don't meet the listing, we're going to look at how they're currently functioning. And again, if they're a younger individual and even if they have some limitations that would maybe limit them to, light or sedentary type of work, they might be found not disabled. However, as they age, they might run into a situation where they would be, in the same sort of functional capacity, but once they reach 50 or 55, they might then be allowed because of age. The other thing is that, you're absolutely right. They can become progressively worse, and so if they continue to maybe run through the appeal process, as I have listed up here, once they get to the reconsideration process, maybe things have gotten a lot worse, and then at that time they might be considered disabled and meet some of the criteria for the listings, or have their residual functional capacity become so significantly limited that they might not be able to do that work anymore. So, and again, depending on age, but.
And I would say another kind of scenario, because obviously the definition includes 12 months. So if someone who was just diagnosed with a particular impairment, and we have not seen that 12-month, we might need to, well, first of all, see what the listings say about that. Some of the listings will say we need to see what's going on with that person later on. So we might have to medically defer it for a while and then get medical updates. There's also a scenario that, it could be that it's going to progress and we can project out to ensure that we have that durational piece met for the program. Now, that doesn't mean that someone can't apply. I mean, right. Anyone can apply at any time.
Right, and we do encourage that. Anytime we're asked that same question, we always lean on the side of go ahead and apply and just let the process go through the steps it needs to, but that also doesn't mean you're always going to be denied benefits if the first time you receive a notice is a denial. As an impairment gets worse, we encourage reapply and go through the steps.
Does that answer your question?
I have another question. If a physician recommends surgery and the claimant refuses that surgery to correct the impairment, does that have any bearing on a decision?
Well, that could be a tricky scenario. It depends upon what's going on with that person. There's some examples that Social Security will, has, talked about with us that, for instance, if someone has significant visual loss in one eye and they're potentially facing a surgery with the other eye and that scares them, they don't want to lose complete vision, that might be, a legitimate reason for them not to want to get that surgery. Cost can obviously be a factor. There's just all kinds of factors. That doesn't mean we're going to hold up in making a decision on that claim. And I guess it depends upon the situation. I mean, there's some folks that maybe if they receive benefits, they could get the treatment they need. Those are factors taken into consideration. I mean, we've seen claims of folks that maybe need a knee replacement, for instance. They're severe now, bone-on-bone kind of situation. We're going to evaluate that as it is in the moment, and I guess if they get surgery in the future, then we might see that case later on as a continuing disability review and find that they've had medical improvement.
Yeah, I mean, there are scenarios, it's not too often there isn't a justified reason, but there are scenarios where we can use not following prescribed treatment as a factor. But usually when we dig deep enough, there is a cost factor, insurance, the lack of insurance, things like that create a justification for not following through.
And on the flip side, if someone does get surgery and we anticipate, that will correct or help the situation get better, we might have to defer and do a medical decision after, we can get some progress notes to see how they're doing after that surgery.
I have another question about looking at past employment. Do you look at, or do you take into consideration people who have had multitudes of jobs that, looking at, they've had a job for 3 weeks, a month, 2 months, 1 week, so their history is showing that they really can't hold a job even though they've had many jobs?
I would say that does bear into the factor. I think, I forget which one of you, Joanna probably alluded to the fact that us having to work through and look at work issues is probably one of the most challenging and difficult parts of the job because of folks that hop jobs and have had an assortment of different jobs. And so bottom line is we need to determine, did they do it long enough to learn the work? Did they work it at SGA? Those are critical parts of it. And fortunately or unfortunately for whoever's perspective, we have to look at a full 15 years. And so that's quite arduous for folks who have worked many jobs. Can it play a role as far as their ability to be able to work? Yeah, I think that's taken into consideration when our medical consultants are reviewing the case. Whether or not they're failing and having difficulties at maintaining a job, yes, I would say that is a factor.
When we, especially with psychological impairments, one of the things we're going to be looking at is the ability to adapt to new and different situations. Maybe concentration, the ability to persist at things, the ability to work at a relatively good pace, those kinds of things. So with somebody who maybe is having struggles with keeping a job and being able to be there, that might be a piece of the pie that is supporting that limitation. So that's a good point.
So do you work
and
with
we see a lot of... I'm sorry.
Do you work with Social Security with that? Like these folks that really can't remember if they've had so many jobs and they're 15 years back, they just don't have that information available to them. Do you work with Social Security to get that information?
We do have access to people's earnings records and employers that they've worked for. We can use that as a guide to help people remember. And bottom line is if they can't remember it all, we're going to get as much information as we can. That's going to be material to making a decision for the case.
Thank you.
Thank you.
Thank you. Any other questions?
We have one more question.
Okay.
Can you hear me okay?
Yep.
Okay, so let's say somebody 10 years ago worked at McDonald's or something straight out of high school or whatnot. And would you guys refer them back to that job if they can do it, no matter what they did, regardless of what they did? If they've done it in the past, you'll refer them back, right?
Yeah, so it's based on the title of a job or types of jobs. So, for instance, that would be considered a fast food worker potentially. So, yeah, we would say you have the ability to be a fast food worker in the way that you have described it to us. So that's how it would look.
Yeah, it's really based on that 15 years. If you did it long enough to learn the position and it was at SGA level, we can basically make that referral back to that past work. The Social Security Administration doesn't really look at the criteria that you're now a doctor and that you no longer have that ability to sustain your current employment. They actually can, basically use that past work to, and SGA is a huge part of it. So.
Would that then determine or adjust the amount of your disability payment?
Oh, if someone's able to be returnable to their past work, that's a denial.
Oh, all right. Sorry.
Yeah. Yeah.
I'm learning.
That's okay. So, past work, if a person is able to be returnable to it, either how they described it or how it's described in the national economy, that's a denial.
Okay, thank you.
Yep. Any other questions?
All right. So the next thing I want to talk about here is notice and appealing the decision. So if you're denied at the initial level, you can file a reconsideration claim, and what happens with that is that filing happens through the Social Security office. So they take that information that you want to appeal the decision, and then again they send the claim to us. What we do is make sure that that claim is assigned to a different analyst or examiner, and a different consultant will look at it, so it's a new pair of eyes on not only the information that was presented at the initial level, but any new information that might be out there. So we'll definitely go out and get new records and any updates that might be available. So if the person is denied at the reconsideration level, excuse me, they have the opportunity to go in front of an administrative law judge to have a hearing, and at that point they can present witnesses and any other additional information that they might have, and the administrative law judge will make a decision from there. The appeals process can go on in terms of being reviewed by an appeals counsel. There are some parameters that go into what the appeals counsel does with that claim and how that appeals process works from there. And ultimately it can go in front of a district court and Supreme Court depending on what the issues are. So those are all referrals that are made at those appeals counsel level. So there are multiple. Sure.
What about an expedited reinstatement? When do you do that?
So those happen after somebody has been on benefits and then those benefits are ceased for particular reasons. An example might be, if a person went back to work and they'd been ceased for that, and then if it looks like that particular impairment wouldn't necessarily get any better, then that would prompt the system to say, yeah, this is a situation in which they could be reinstated without having to go through an entire re-adjudication of the claim. So we're going to look at it's just kind of an expedited, closer look at it. So,
as far as Social Security goes, we look at the work activity. It has to be you have to apply for that EXR within 5 years of when those benefits stopped. And then we have to evaluate the work activity from the point they file 12 months retroactively before we send it to DDS for that medical decision.
Yeah, and go ahead.
And you could also do an expedited application if the person is terminally ill and not expected to live 1 year. Is that correct? Is that a different form? That's kind of off subject, but I forgot to ask that.
Yeah,
technically it's not an EXR. Yeah,
that's a different scenario.
Right.
Did the person who had the question about the EXR, was that answered adequately?
Yep, that's answered. Yeah.
Yes.
Okay. And as far as the terminal illness, we call that TERI, or it could come in as QDD or CAL. QDD is quick disability determination, and CAL is compassionate allowance. And so those can be and are expedited in the office.
Yeah, and EXRs are too. We really strive hard for the priority type of cases to move those through as quickly as we possibly can.
Thank you.
Mm-hmm. All right.
All right. Another myth that goes around is, and this is similar to the last myth that we had, but basically, do you have to go before a judge to get on disability? I gave you some numbers before, but I'll give you a little bit different numbers this time. No, the South Dakota DDS allows 38.9% of initial claims. And that's compared to 33.2% nationally. Now, there's been some speculation, and there's no facts behind it. There's no way to quantify these numbers as to why South Dakota allows more than the national average. But there is a pattern within the Midwest that really shows a higher allowance rate within the Midwest. And the decision or the estimate that we have kind of come up with is that the work ethic, the strong work ethic of the Midwestern individuals they're hardworking. They're going to work until they basically can't work anymore. And so they will try harder and work longer than some that live in other parts of the country. So that's, again, that's not necessarily based on any facts other than just the discussions within SSA and other DDS administrators. That's kind of the numbers or the facts that we've really kind of come up with. We do also, allow 13% of reconsideration cases, and another misnomer, and that this fact isn't really going to help, but the administrative law judges do allow about 50% of their cases. Now, you have to realize the number that actually goes to them gets smaller and smaller. So it appeals of cases from initial to reconsideration already go down to about a quarter of what originally filed. Then from there, they go down even further. I wasn't able to come up with actually South Dakota specific administrative law judge facts, but I was able to come up with basically the allowance rate. Now, there's different things I want to stress is administrative law judges that we've talked to in the past really say the case that is presented before them is really a brand new case. And I'm saying that because it takes right now on the website that I was able to get the stats from, the West River in South Dakota is serviced by the Denver area administrative law judges. And their processing time right now is 1 year, 8 months. The Fargo area administrative law judge office services the eastern half of South Dakota, and their processing time is currently 1 year and 5 months. Now that's the case that goes before the judge, somewhere in between there, and then it takes them a while to write up their decision. So in between there, people have to make life choices and say, am I really that hard off, or I need to find work and I need to really have the income. I can't wait any longer. Well, that process it might force people outside of their comfort zone, but it does encourage them to potentially drop out of this pool. And so the people that are probably the worst off, have the hardest impairments, that are willing to wait that long for decisions, are the ones that, and that's why the allowance rate is at a higher rate. It's not that if they had all 5,200 initial cases that we see here, that they would allow 50% of them. So, the longitudinal evidence is another huge factor. They're seeing another year's worth of medical evidence that we don't see. And that plays a huge factor. If we had if we had another year's worth of medical evidence, our allowance rate would probably be higher than it actually is right now. But most of the time, people are applying shortly after they lose employment. And so that makes our window into the longitudinal picture of evidence very short. And that just makes our job that much more challenging. So those are some misnomers I wanted to make sure and get out there. Anything else to add? on that.
All right, thanks. Okay, so once somebody is on disability benefits, it doesn't necessarily continue forever. There is a periodic review process that we follow here in our office, and generally the review period is about 3 years. So there are some types of impairments that might require a review to be done sooner. There are some that require or allow for that periodic review to happen later. So it just depends on the impairment. Something that is not going to get better, and this is a medically known fact, we're not going to review those as often. So, and when we are doing a continuing disability review, we're not re-adjudicating the claim using the process that was laid out earlier. Rather, we're looking for medical improvement. So we're going to take a look at how they were functioning and when they were first allowed, and we're going to take a look at how they're functioning today. If there has been no significant improvement, we're going to say the benefits will continue.
Surgeries.
Yes, so if they've had maybe a surgery and they've had some significant improvement in their function, they're able to do a lot more than they were able to do before, as we talked about earlier, that would be a situation in which the benefits would be expected to end and they would be able to go back to work. So, any questions on that? Okay.
All right. So a few more stats that I get to play with is the productivity. The productivity for our office is actually pretty high. We process 5,650 cases, initial cases, and that was in 2016. Reconsideration about 1,500. CDRs a little bit over that, and then we do complete a few other claim types. We assist the judges the administrative law judges that receive appeals at their level. We'll get exams for them. Again, like we talked about, it might be a year from the time they might have had an exam for us, so they need more and new evidence. There's also a reconsideration process through the continuing disability review. We do some claims there, and then we also have an additional level of appeal in that continuing disability review process. If we determine for basically the continuing disability review, the pre-hearing review process, we're still determining that we're deciding that we're going to take somebody off benefits. We have an additional level because we want to take that we do take that very seriously because that's a huge impact to individuals' livelihood when they're used to having that regular paycheck. So we have another level of review. We have 3 hearing officers in our office that actually have face-to-face hearings with individuals, and some of you might be impacted by those because we actually use the rehab offices around the state. So thank you very much for your guys' services in assisting and supporting us in that. And that's really where those individuals come into play, is that they've been on benefits. We've denied them not only once, but we've actually affirmed that we're going to cease their benefits. So we have this face-to-face hearing with our hearing officers. Anything more to say on hearing officers? Okay. So the total cases, we processed about a little over 9,000 last year, and that varies from year to year depending on our staff size and the workload that actually is sent to us from the Social Security office. Okay. Processing time. We process 52. We process our cases on average 52.5 days. Now that's from what I'm quoting is the time from assignment to our examiner to the time they make a decision. Now the processing time that is not factored in there is the amount of time it takes, and it sits in our backlog of cases. It can nearly double the amount of processing time before it actually can be assigned to an examiner or an analyst in our office. So when we usually get a call from an individual, we do try to expedite and assign those cases, but that is a factor I wanted to make sure and point out. Accuracy. We talked about the national consistency that we have, and South Dakota is always ranked towards the top of national accuracy, and we match the national accuracy rate at 97.8%. So I'm very proud of our staff for that. All right, another myth here. Now there is some documents, or there might be some verbiage that's used in some documents that go to claimants that say a claim needs to be done within so many days. And how it comes back to us is we were promised that the decision was supposed to be made, or we have to. They basically instruct us that we have to have the decision made. Now, as I just referred to, our processing time from the time on average is 52.5 days, but we can't really control our backlog of cases. And as I said, that sometimes a case can sit there for an additional month and a half to 2 months before it actually is assigned. So we try to be as courteous as we can with individuals that talk to us about those. But again, if they call us and they acknowledge wanting their case seen, we do what we can to expedite those cases. And just to kind of refer back to the last fact, just real briefly, we have a pretty high processing, or we expect quite a bit from our disability analysts. For analysts that have been here for over 4 years, we expect them to produce at the very minimum 489 claims a year. But we really prefer around 600 claims a year. We always have a backlog. The cases are always there. So we're able to actually hold our staff accountable to a certain number of cases, comparatively to maybe some other agencies that might not have the guaranteed numbers to be able to have that. But here at the DDS, we do have those numbers.
Any questions on any of those statistics?
All right.
All right. Well, we're going to shift gears a little bit here. One of the topics we wanted to discuss was just sharing of information across agencies and how we go about doing that. And so, excuse me, requests for medical records. The DDS may request records from vocational rehab, for instance, and when we do that, we're seeking copies of your case notes, any exams that might be requested by vocational rehab, so anything that's generated by the rehab office. And we realize that with HIPAA rules and guidelines and policy, that you're not going to be providing us with any records that you might have gotten from some other secondary source. So I just wanted to point that out. And then, vice versa, Voc Rehab may request records from the DDS as well. And So we'll release records from any consultative exams that we've ordered, and generally that is probably the limit that we're going to be producing any sort of record. If we don't have jurisdiction of the claim, so for instance, maybe a claimant has already gone through the process, we've made a determination about the claim, and if the claim is back to the Social Security office with a determination, at that point we can't release those records. You would have to contact the Social Security office for that, and so Katie and her office would take care of that depending on where it is. And I believe that there's a charge that's done for processing fee. Is that correct?
Normally, yes. Sometimes, it depends what their reason for needing those records are, or if there's an attorney involved, if they're wanting records for a pending claim or, a pending appeal, there's not going to necessarily be a charge. But if everything is closed and they want it for workers' comp or just to have the records or whatnot, then there is a fee. I don't remember the set amount offhand, but it depends on pages, records, if they want a CD, things like that. And there's a certain form that they have to fill out. It's the 3288 in order for us to release that. And then we have to go through some of the records too and see if they are able to be released or if they have a medical condition that they should not be reading some of the records. So we have to go through that process before we can release them.
Good. All right. So from the DDS perspective, when we're requesting to vocational rehab, the DDS, we have a customized request that we will use for making that request. And I'll go ahead and pull that up here for you in a moment, what that looks like. But when making the request, we would ask that when you're filling it that you use this 800 number that is included here. So if you fax that into this number, it'll go into the claimant's file. So, and then there's a barcode sheet that's also attached to that, and I'll show you what that looks like here. So this is an example of that. What that looks like. This is the front page, and then there's a barcode that's part of this page, and then on this is the actual request. So this is going to tell you the information that we want. So for vocational rehab, we have a specific request that we use for that we don't use for other sources. So we're asking for trial work, case notes, and exams completed by rehab services. And then information about how to send that. So again, that 800 number is on here, right here. So any questions about that? All right. Well, the other thing I wanted to show you is when we send it for a request, we're going to be sending an authorization along with that. So you'll see a form that looks like this. This is the SSA 827, and it'll be completed and signed by the claimant here. So. Okay, so vocational rehab requests to the DDS. So the DDS requires an authorization to release information. So now you can certainly use your own authorization if you have one, and that would be perfectly acceptable. If there is one out there that you can use that's produced Social Security, and that's called the SSA 3465 form. And if you have the individual fill this out and sign it and indicate what it is that you want, then we can fill that request for you. When you're sending a request for records, one thing I would like to stress is to either mail it or you can fax it to this number listed here. This is our administrative fax line. And that's the best one to use. We definitely don't want you to use this 800 number that I had referred to before. We don't need that information going into the file, so and it would it would get filled by, or the examiner would be the one to see it, and then they would not be the one to fill it. So that would create some confusion. So definitely would ask that you send that to the 367 number here. Is there any questions about that? All right. Well, with that, it brings us here to our Q&A time. And I know, Joanna, you had received one question from an individual that...
Yeah, on stat blindness, and I think Angela will kind of cover some criteria for the stat blind.
Jeremy, if you want to pull up the listings
Sure.
as well,
I can do that.
just to show our audience what the listings look like. The whole issue of blindness is actually covered really well under the listings, and it would be under special senses as the body system. As far as stat blindness, there are 2 listings that we look at for stat blindness, and what the definition is central visual acuity of 20/200 or less in the better eye with the use of a correcting lens. And if that is the case for someone, that they have visual acuity of 20/200 or less in the better eye, we're going to find that they're going to meet the listing criteria for 202. And everything that I'm describing here is actually in the introductory text of the listing, and looks like Jeremy has that pulled up. So this is all there. And the second way to be found statutorily blind is through visual field limitation, and this is I'm not an expert on blindness, but I know that when we meet this listing, there's a little bit more work involved. But it's a visual field limitation such that the widest diameter of the visual field subtends an angle no greater than 20 degrees is considered as having a central visual acuity of 20/200 or less. And if you have that, you would meet listing 203A. Those are the only 2 listings for vision that you would be considered stat blind for the program. How we would look at acuity, pretty much the Snellen. If you've all heard of the Snellen, that's probably the most common way of looking at visual acuity. We'll also see visual acuity recorded as count fingers, hand motion only, or light perception only, or no light perception at all. And so that would also equate to meeting that listing if that's the case in the better eye. As far as evaluating visual fields, we would do that through pyrometry, and there are the acceptable tests that SSA looks at are the Humphrey Field Analyzer 30-2, as well as the 24-2, or the Octopus 32. And I don't think anyone in South Dakota does the Octopus. So we are looking at the Humphrey Field Analyzer here in South Dakota. So I don't know if that answered the question, or if there's anything more I can say about that. Let me know. Okay, are there any other questions?
I have a question. When people are on Medicaid and then they're eligible for SSD, that throws them off of Medicaid, but they can't get on Medicare for 24 months. And in the meantime, I've had 2 clients that are on oxygen, and they can't afford to stay on oxygen because they've lost their Medicaid. Is there any way we can get them back on Medicaid, or not at all?
We usually get that question in our office, and we would refer them to social services basically to see if they qualify for Medicaid through them under another program, because if they're not receiving an SSI benefit, we cannot give them or tell the state to give them the Medicaid. The only exception to that is if it is a person that's over 18 and they are not receiving an SSI cash payment because of their own work activity puts them over the limit, then their Medicaid will continue. But any other situation besides that, yeah, we refer them to the state to see what other medical help they can get in the meantime.
Okay, thank you.
All right. Any other questions?
Yes, Sioux Falls has a question.
Okay.
In the very beginning, you said that you're short of doctors. So if you know someone who may be interested, what would you need to tell them to do?
I would say, yeah, have them call our office so they could contact me or they could contact Joanna.
Your information.
Yep, and my information is on the PowerPoint.
Okay.
So, there. That would be wonderful. We would appreciate that greatly.
Thank you.
Yes, thank you.
Yeah, the nice thing about consultants is they can basically work on their schedule. It's very part-time for them, and they can work after hours at our office and on weekends. And so we definitely value getting some good support in that regard.
Yes. All right. Any other questions? Got one more topic. And Joanna's going to talk a little bit about fraud in Social Security.
Okay, well, I believe the official date was October of 2016 when the official fraud unit became active in South Dakota. Really, the Bipartisan Budget Act of 2015 really indicated that was a federal law that basically said there's going to be money set aside for setting up fraud units in each state in the union. So the South Dakota did officially start their fraud unit. And part of the reason why I wanted to talk about it is because the DDS does play a portion. So it's Social Security Administration plays a portion. Now the unit is actually led by the Office of Inspector General. On the screen you see the OIG website, and this is their main page. And so one of the things, if you come across the case or come across a situation where something doesn't feel right and you want to, even if there's just a suspicion of fraud, what we're learning is that they just encourage you to submit the suspicion of fraud. So you can go to the OIG's website. Well, this is actually oig.ssa.gov is the website. So if you scroll down to the bottom of this main page, further, up to the toll-free number. Yep, there's a fraud report form that you can fill out, an internet form. Okay, there is, yes.
This is Janet in Pierre. We have a question in Pierre.
Okay.
If you suspect a PE is misusing an individual's funds, is this where you report that as well?
Right, yes.
Thank you.
Yeah, I'll go over some criteria here from their website here in just a minute. But yeah, basically there's several different ways that you can report the fraud. There's the toll-free number there, 800-269-0271. Again, it says from 10 to 4 Eastern Time. And then there's also a TTY toll-free number for those that are deaf or hard of hearing as well. So, but really what this does is there is a DDS analyst that will be on board, and that individual will be charged with reviewing cases at the DDS level for suspicion of fraud. Some of the policy indicators that they say is, it might be something we look into when a whole family goes into the Social Security office and they make it a family day to everybody applies for Social Security disability. That's usually a red flag that maybe something is up with Social Security. Go ahead and go to the top of the screen. See the Social Security. Go ahead and go down and off to the left. Sorry,
It's too big now.
Okay, the top. What is fraud? Fraud, waste on the left. There. All right. So, some of the examples they have on here: making false statements on a claim. Obviously, if you have twin daughters and one maybe has a significant learning disability and one doesn't, and they try to or there's some suspicion as to whether or not the right daughter is at the right is filing for both, or that has been found to be an issue before, where another family member does pose as the individual that is claiming disability falsely. There's concealing facts or events which affects eligibility. There's one thing that we do at the DDS right now is we always request medical records. It doesn't matter how many medical records were sent. More than likely, the information that is submitted by the claimant, more than likely that's not enough information for us to make a decision. So with that, we always take that extra step and request the records, and that's only because if there's a statement in there that encourages the person to go back to work or making a referral regarding work, there might be that temptation to conceal that information. So we do that on the DDS side. There's misuse of benefits by rep payees. That is definitely, I think that's some of those things have hit the national news. There's been judges, there's been SSA employees. I'm sure there's probably even been DDS employees that have all been bribed to a certain degree. I think Puerto Rico was a national news, made the national news on 2020, and probably various other national news agency or national news reports. So, there's workers' comp fraud that they also look into as well. So this website, again, is oig.ssa.gov. It's access. It allows you to access it. So feel free if you have a suspicion. Just so you know, too, as far as the state involvement in this agency, several state law enforcement officers will also be involved with this unit, and they'll be stationed. They'll be covering the entire state, but two will be stationed out of the it's the ALJ office, right?
In Rapid City.
In Rapid City, yep. Yeah, I think they're looking at doing the administrative law judge office. Two will be based out of there, and then two will be based out of the Social Security office here in Sioux Falls. I think the official construction of the unit space has, I think, technically been started. finally started. It's been a long time coming, and then the Social Security office also has a rep that is on this OIG team as well.
There's a SSA program analysis is their title, so they look at the Social Security side, the record, and things like that. And just to mention too, the website, is a great place to refer those, but you can always call our local offices as well, because if you're mentioning rep payee misuse or working when they shouldn't be, there's a lot of follow-up questions that we might have to get all that information that OIG is going to need to process that. So you can always call into the local offices so we can kind of get more of what we need, so we don't have to do that recontact with you, maybe.
Good. So yeah, the fraud unit should be fully underway, hopefully before the end of the calendar year. There'll be some training and an adjustment, but in the meantime, I would suspect that South Dakota will have an increase of fraud claims that they will be able to investigate. They're taking this fraud and abuse is a very serious matter that the federal government is taking more seriously now than they ever have before. So just if you have any questions on that, you can contact us here or contact your local Social Security office.
The one thing with the new fraud group, I guess the CDI unit that it's called, our OIG agent has a lot of meetings with people throughout the state, at nursing homes, at banks. There's a whole group that gets together and meets. So if you refer something and it's not necessarily developed by Social Security or at the federal level, sometimes it transfers over to the state and it's looked at through different criteria.
Good.
Any other questions? All right. Well, we want to thank you guys for your time this afternoon to start off your work week on a Monday afternoon. And I think that's all we have. So thank you very much, guys.
Thanks, Joanna.
Thank you. All right. Have a good rest of your day.
Your call will be disconnected.